May I please, Your Lordship?
Yes.
Your Lordship, paper book received in this case, Your Lordship. Matter will be fixed for hearing, Your Lordship.
We'll go for hearing.
Service report in respect of R2 is not yet received.
Service report they waited.
Oh, sir. Respondent number 2.
Yes.
It will look better you take fresh
Yes, Your Lordship.
heard and direct counsel, Mr.
E. Menjo, Your Lordship.
Tips for service of notice upon respondent number 2 by registered secretary. List up to 4 weeks.
Much obliged.
Obliged.
May I please, ma'am?
Yes.
My lord, this IA, my lord, 7 of 2024, my lord. This is for my lord suspension of the my lord sentence, my lord, by which 20 years imprisonment has been awarded to the accused person, my lord. My lord, basically, my lord,
Notice served or not?
my lord, is private
Your
party is there, my lord. My lord, basically, the facts of the case, my lord, under what circumstances, my lord, the admitted fact, my lord, on the record, my lord, under what circumstances this case was registered, my lord. Admitted position is on the basis of record is, my lord, 2021, my lord. This accused and the victim, they became friends through Facebook, my lord. So in the Facebook, the victim disclosed her age, my lord, as 8/3/2001. It is the admitted fact, my lord. That Facebook profile has been also exhibited in the case record, my lord. Now, my lord, then, my lord, what happened, my lord, in 2021, they became friends. They started having physical relations. There is no dispute to that extent, my lord. Then, my lord, what happened? They, as per the record, my lord, for 3 times, my lord, they had a physical relationship. To my lord, of the accused person, the victim accompanied the accused in his house in the presence of mother. In the presence of the mother of the accused person, they developed physical relationship. So, my lord, thereafter, everything was going fine. Then, in the meantime, because of something, there was miscommunication, no communication between them. Then, very lately, victim came to know that she became pregnant. When she became pregnant, then, my lord, she informed the matter to the parents, my lord. Then accused was called. They tried to resolve the matter. So accused raised the issue since, of course, I admit that we had a physical relationship for 3 times. But since there was a long gap between us, there was no relationship. So I doubt that I'm not this biological father of the child. Unless the paternity test is not done, I'm not ready to marry. So that's why matter could not be resolved, my lord. Matter remained there. Then, my lord, only when the matter could not be resolved, my lord, on 3/5/2022, after almost, my lord, 9 months delay, the FIR was lodged, my lord, against the accused, saying that, my lord, now in the FIR says that forcefully physical relationship was developed. Thereafter, he was arrested. Then the, my lord, charge sheet was filed, my lord. Then trial proceeded, my lord. Now, in the meantime, my lord, during the, my lord, trial, on 14/5/2022, the victim gave birth to a baby girl. Then, following which, my lord, then DNA test was also conducted, my lord. Then paternity test, my lord, this accused paternity, this DNA profile, my lord, matched with the baby, my lord. Then accused admitted, my lord, okay, I am the biological father. Then, my lord,
What is our evidence?
Evidence, my lord. So far in the case, here the age for
Amendment. Mr. Expert, having considered that the respondent number 4, that the particulars and the address of the respondent number 4 was given as care of to the Secretary of Public APPSC, Itanagar, Arunachal Pradesh, which is not the correct address of the respondent number 4. We deem it appropriate to allow this application for we deem it appropriate to allow this application by allowing the applicant to amend the course started in respect of the particulars of the private resident number 4. Accordingly, what should be the address you have given?
Yes, Your Lordship.
Mr.
That is care of Director General of Police, Government of AP, Your Lordship.
Mr. Accordingly, the applicant is allowed to amend the course title in respect of the particulars of respondent number 4. As the care of the Director General of Police, Government of Arunachal Pradesh. That's all.
Lordship.
The IA stands allowed and disposed.
And Your Lordship, another IA number 151, Your Lordship.
Yes.
Here,
51 is
151 is in respect of respondent number 4, 5, and 6, Your Lordship.
same address.
Same address,
Okay.
4,
You
5, and
just
6.
add that, 4, 5, 6. Same address, huh? Same address. Only 4, 5, 6 has to be changed. In place of 4, you said that respondent number 4, 5, and 6.
Obliged.
Just wait. In view of the writ appeal, huh? In view of the order passed in IA so and so, huh? In both the appellant to file the amended course title along with the particulars of the private respondents list of On such filing of the, no, thereafter, registry to issue notice to the respondents.
Obliged.
Same order in both the
Both the appeals.
appeals. And list after 3 weeks. 3 weeks. In the appeal, huh? This goes both the way. Hearing.
Please, Lordship.
Yes.
Lordship, before making my submissions in this matter, Your Honor, just like I looked up apprise the Lordship that the paper book which has been provided to us, Your Lordship, in the paper book, Your Honor, the judgment of the London Trial Court can be seen in the paper book, which is in 76.
26.
It's in the judgment copy of the London Trial Court. And Your Honor, the page, Your Honor,
Page number?
page number 112. No, Your Honor, 112, Your Honor. Now, if you see this page, Your Honor,
112.
yes, 112, this is the page, Your Honor, the para 46, 47 and 48, where the decisions of the London Trial Court, Your Honor, it's missing, Your Honor. If
Oh, so
it's not in my, here. the
47,
paper.
48 not available here.
Yes, Lordship? It's missing, Lordship.
Learned Counsel MS. What is your name?
Dioka.
If the appellant has pointed out that the paper book prepared by the office does not have the paragraphs 48 and 49,
48, yes.
48 and 49
Yes,
of the impugned judgment,
47, 48,
47 and 48.
page 39 of the judgment is missing.
47 and 48 of the impugned judgment are not available in the paper book. I have also heard MSTG, the learned National Public Prosecutor for the state of Arunachal Pradesh. The registry is directed to provide the paragraphs 47 and 48 of the impugned judgment to the learned counsel for the appellant, as well as MSTG. Least after 3 weeks.
boleh mama. Lord,
Yes.
this appeal is directed against the impugned judgment and conviction dated 11/8/2023 passed by the district administration judge come a special judge Bosco Pasigar. Now, my lord, without proving the foundational fact on probabilities of preponderance, the accused has been convicted in this case, my lord. I'll not take too much of the time, my lord. Has been convicted, and that too, the learned special judge, my lord,
has imported his own view in the judgment, what is established there in the law, which is not supposed to be done. I'll establish from here. Kindly come to FIR, my lord. Page 1 to 3, my lord.
Page 1.
Yes. Page 2 is the FIR.
Hmm.
With due humble submissions, I have the honor to inform you that my daughter, so and so, 4 years and 11 months studying in LKG, found urinating without control since 26 January 2019. My lord will mark this 19th January 2019. My lord.
Yes,
My lord, I beg to mention item number 4, my lord.
just a minute. Item number 4.
4, my lord. My lord, this matter may kindly be, my lord, taken up after the vacation, my lord.
Okay.
I've taken the consent, my lord.
On the request of Mr. R. Sonar, the learned counsel appearing for the appellant. The matter is adjourned today. List after the ensuing vacation.
Mature.
And in indulgence to item 27, my lord,
Hmm.
I have taken consent from my brother Pangin. It will take long time also, my lord. I will be out for long.
27.
27, we have agreed upon for 24th of September, my lord.
On the request of the learned counsel, Mr. T. Gitara, the hearing is adjourned today. When?
24th September.
On 24 September.
Yes, my lord.
List on 24 September for hearing.
Interim order to continue.
The interim order past will continue.
Much obliged.
May I
Yes.
please, my lord? My lord, with consent from the other side, my lord, I beg to mention item number 5, my lord.
Item number
Item number 5, my lord.
5.
Yes, my lord.
You are for the appellant.
Yes, I am for the appellant, my lord. Matter may be taken after 2 weeks, my lord.
Okay. The learned counsel, Mr.
M. Doshi, my lord.
appearing for the appellant prays for an adjournment and also submits that he has already informed the other side. Accordingly, the hearing is adjourned, accordingly, the matter is adjourned today. Least after
After 2 weeks, my lord.
2 weeks.
Obliged.
Admission hearing. Yes,
Your Lordship, I would like to mention item number 21. Your Lordship, we need some time to file the rejoinder. It may,
also Mr.
VT Gurung, Your Lordship.
appearing for the petitioner submits that he needs some time to file a rejoinder in respect of the reply filed by the respondent.
Yes, my lord, on behalf of respondent.
I have also heard Mr.
N. Rama.
N. Rama appearing for the respondent.
Also, Your Lordship, there is an interim order.
The prayer for, the prayer of the learned counsel for the petitioner is allowed. When do you want it?
So 1 week, Your.
My lord, 1 week maybe, they have already taken time for rejoinder.
Least after 2 weeks.
Yes.
The interim order pastel shall continue until then.
Oblige, Your Lordship.
May I, Lordship?
Yes,
I'd like to mention item number 31.
31.
On behalf of T. Thakur,
31, yes.
leading counsel is out of discussion.
You are appearing for D. Tamuk. 31.
Yes,
You are appearing for whom?
T. Thakur. T. Thakur. On behalf of T. Thakur.
T. Tadu. Item number 31.
Yes, Lordship.
Oh, it's for the respondent. You're the petitioner or the respondent?
The response is,
You're for the respondent. For T. Taki,
yes, Lordship.
have you informed the other sides?
Yes,
The learned counsel, Mr. What is your name?
BCO.
Appearing on behalf of Mr. T. Taki, the learned conducting counsel for the respondent praised for an adjournment. The learned counsel further submits that he has already informed the other side. Accordingly, the hearing is adjourned today. When do you want it?
2 weeks.
Least after 2 weeks. Is there any interim order pending?
No.
Yeah, Lordship.
Yes,
Lordship, I beg to mention item number 25.
25.
Lordship, I am appearing on behalf of Mr. T. Taba.
You are appearing for B Taba,
T. Taba.
B Tabang.
Yes, Your Lordship. Lordship, matter may be
Item
kindly
number
25.
25. But his name is not here in the pod list. B, what is his name?
T. Taba, T. Taba.
T Taba.
Yes, Your
Oh,
Lordship.
sorry,
He's the conducting council, Your Lordship.
okay. D Learned Council MS, what is your name?
N. Hondik.
And Hundi appearing on behalf of Mr. T Taba. Praise for an adjournment.
Yes, Your Lordship.
The prayer for adjournment is allowed. When do you want it?
Matter may be fixed after a week.
List after 2 weeks. Is there any interim order pending?
No, Lordship.
List after 2 weeks.
Much obliged, Your Lordship.
May it please your lordship.
Revision petition.
Yes, criminal revision petition,
Is it against the judgment or order?
impugn order, my lord.
Where is the order?
My lord will find the impugn order at page 77, my lord. It is an NIA proceeding, my lord, wherein, my lord, 20% was granted of the impugn checked amount without, my lord, considering the facts and proper perspective, without considering the law that has been laid down recently by the Honorable Supreme Court in Rakesh Ranjan Srivastava. My lord is aware of that law, my lord. My lord, before I take, my lord, to the impugn order or read out the impugn order, my lord, may I, my lord, invite, my lord, to page 26, my lord, annexure 1. Page 26. I'm just
Yes, it's an agreement.
yes, my lord. It's an agreement, my lord. Before taking into the agreement also, my lord, the respondent, my lord, is a proprietorship firm, my lord, and the proprietorship firm is being run by one person named, my lord, Riro Tabio, and the petitioner before, my lord, is K. Raja, my lord. Why I'm submitting before, my lord, this aspect, my lord, because, my lord, the respondent was given, my lord, a work order by the Itanagar Municipal Corporation, my lord. The respondent was given the work order. Thereafter, my lord, the work order,
Yes.
thereafter, the work order was sublet to the petitioner, my lord. And this is the agreement by which the work order was sublet, my lord. My lord will kindly see second paragraph, my lord. This agreement made this 12th day of 2019, so and so, between so and Rido Tabio so and so, address, my lord, so and so, proprietor of so and so, Kurunkume Enterprise. And my lord will come down 2 paragraph down. It is the first party, and my lord will again first party, unless excluded by and repugnant to the context, be deemed to include a successor on one part, Sri so and so, who is the petitioner before my lord. And my lord, by this agreement, the first party was allowed to open a bank account. The first party allowed the second party to open a bank account, and he was supposed to carry out the work in the name of this firm, because respondent has sublet the work to the petitioner. Thereafter, my lord, running bills were issued, and my lord will find at page 33, my lord. After the work was done, my lord, some running bills were issued, and my lord will find that from annexure 5, page 33 onwards. And I will conclude it by saying, my lord, that some about 9 crore 63 lakhs were issued as running bills because the petitioner carried out the work. In the meantime, my lord will find, my lord may kindly come to page annexure 2, page 29.
Check amount was for 93 lakhs.
Yes, my lord. Well, I will take that to that part also, my lord. But kindly, my lord, may kindly come to page 29, my lord, for a moment, my lord. Page 29. This is the bank account that was opened by the petitioner on the behalf of the firm. page 29, my lord, this is a bank statement.
Hmm.
And my lord will see, the 1st of February, my lord, bank statement, 1st of February 2020. My lord will kindly see RTS Victor and Associates. This is the CA, my lord, of the company who was supposed to, my lord, open the GST account of the respondent firm, my lord, because the respondent firm was blocked due to the arrear dues, my lord.
Hmm.
And CA was paid, my lord, by the petitioner, my lord, 2,50,000, my lord. My lord will kindly see at 1st February 2020, RTAGS Victor and Associates. This CA was paid by the petitioner 2,50,000 to open the GST account of the firm. Thereafter, my lord will kindly come to page Annexure 3, my lord. Annexure 3. Annexure 3. This is the, my lord, the GST account of the firm which is blocked by the, my lord, the department, because the GST account, there is a due of the regarding the GST payment of the firm, my lord, respondent firm. And my lord will see the type copy at page 31.
Okay, I will issue notice to the.
And my lord, what has happened, my lord? My lord, may kindly bear with me, my lord, because, my lord, everything arises out of, my lord, page 42, my lord. My lord, may kindly come down to page 42, my lord, because we have been asked to, my lord, pay, my lord, within 15 days, that too. My lord, will kindly come to page 42, my lord. This is where the cause of action arises, my lord.
Hmm.
My lord will kindly see, this is a deed agreement between the petitioner and the respondent, my lord. At annex clause 2, my lord will kindly see clause 2, my lord. Clause 2, that the so and so amount, 10% GST amount will be so and so, which is to be paid by first party to second party. Second party is a respondent firm. And my lord will kindly come down to paragraph 5, my lord. Paragraph 5. Kindly similar two checks. These were checks were issued for security purpose, my lord. And the impugned check is, my lord, 622,623, my lord. At clause 5, my lord, first party is issuing two post-dated checks so and so amounting to rupees 93 lakhs, my lord. And check number so and so is so and so. And clause 7 is very relevant, my lord. Once we deposit the GST amount, my lord, GST amount has to be deducted from the main amount. So, my lord, what I am basically submitting before this honorable court is that agreement was entered into, and this is not a legally enforceable debt, my lord. This is a GST payment which the petitioner was supposed to do on behalf of the firm for the work carried out by him. But the respondent, what he did, my lord, he submitted the check, my lord. And he submitted a check showing that there is a legally enforceable debt. He filed a complaint case, my lord, before the learned magistrate out here, and showing that the checks has been bounced, my lord. And because of which, my lord, he has filed a complaint case. And my lord will kindly come to the impugned order, my lord, at page 77, my lord. It has been reflected in this impugned order, my lord. Page 77, my lord.
Where it is written that it was checks were given as security.
My lord will kindly come to page 42, then 43 is relevant, my lord.
Hmm.
43, my lord will kindly see. This is the condition of the agreement, my lord. The first party is issuing two post-dated checks, account number so and so amounting to rupees so and so. This amount is mentioned in regards to first of the GST incurred upon the MS Kurunkume enterprise. Clause number 7, my lord. Then later on, if the voucher case memo slip is produced by the first party and duly accepted by the tax department GST, amount will be deducted according from the GST amount to be paid by the first party to second party. So this is GST amount, my lord, admitted. Both the parties have entered into agreement. And my lord, the amount that was given as per the running bill, we are doing the work, my lord. We cannot just directly give him the amount because we are subjected to clause 7. Clause 7 says that once you pay it to the GST department, then it has to be deducted. It has to be accepted by the GST department. So,
Okay, I will just issue notice to the.
My lord-
Let the other party pay.
my lord, 9 we have been asked to, my lord, pay report on payment. My lord will kindly see, my lord, this the latest judgment, my lord, of the Honorable Supreme Court, my lord. My lord, the consideration which needs to be seen, my lord. Kindly, my lord, may I kindly come to paragraph 16, my lord. Paragraph 16, my lord. This is the latest judgment on this aspect, my lord, on interim payment, my lord.
Yes.
My lord, may I read, my lord? when the court deals with an application under section 143A of the NIA, the court will have to evaluate the merits of the case made out of the complainant and the merits of the defense pleaded by accused in reply to the application under subsection 1 of section 143A. The presumption under section 139 of the NIA by itself is no ground to direct payment of interim compensation. The reason is that the presumption is rebuttable. The question of applying the presumption will arise at the trial only if the complainant makes out the prima facie case. A direction can be issued to pay interim compensation. At this stage, the fact that the accused in financial distress can also be a consideration. Even if the court concludes that the case is made out for grant of interim compensation, the court will have to apply its mind to the quantum of interim compensation to be granted. Even at this stage, the court will have to consider various factors such as the nature of transaction, the relationship, if any, between the accused and the complainant, and the paying capacity of the accused. If defense of the accused is found to be a prima facie a plausible defense, the court may exercise discretion in refusing to grant interim compensation. We may note that the factors required to be considered, which we have set out above, are not exhaustive. There could be several other factors in the facts of a given case, such as pendency of a civil suit, etc. While deciding the prayer made under section 143, the court must record the brief reason indicating consideration of all the relevant factors. So my plausible defense before the learned trial court was, my lord, that it is a GST bills, it is a GST payment which I am supposed to pay, and I am in a financial distress, and there is civil suit pending, my lord, before the learned trial court itself, my lord. Nothing was taken on consideration, my lord. So, my lord, and 143A subclause says that the payment has to be made within 60 days, my lord. But the learned trial court directed us to pay within 15 days, my lord. And, my lord, the work order was of 36 crores. We are yet to receive all the payments, my lord. We can pay it, my lord, later on also. What is the hurry, my lord? And
Why did you issue the checks?
my lord, the checks were issued as a security for the GST payment, my lord. It arises out of the deed of the agreement, my lord, 6/9/2022, that the GST payment will be done by the first party. And once the GST payment is done, we have to pay to the GST department, my lord. This is not a legally enforceable debt, my lord.
Okay, let the other party appear.
My lord, may kindly, my lord, because we have to pay, my lord, within 9/9, this was, my lord, fixed, my lord, in the interim order, my lord, kindly see, my lord, for the time being, my lord, till the returnable date, my lord.
No interim order, no.
But otherwise, my lord, this petition will become infructuous, my lord. Because 9/9, it is fixed for, my lord, filing of, on report on payment, my lord.
Not Mr. T. Sunil, appearing for a petitioner. Issue notice to the sole respondent. The petitioner shall take steps for service of notice upon the sole respondent by registered postal hearing. Least after 4 weeks.
My lord, the petition will become infructuous, my lord, if this is not stayed, my lord.
Let the other party appear.
Obliged.
Yes.
May I please? Your Lord, this is filed under section 482 of CRPC.
Is it a joint petition?
Yes, this is a joint petition filed by the husband and wife.
Husband and wife?
Yes, yes, my lord. And my lord, both the party has been settled the matter amicably after incident. So I have annexed the
Ginny?
settlement agreement.
Yes, your lordship, I don't have any objection if this is disposed of at this stage, your lordship.
Under what section the case was registered? 498A.
My lord, it is a 498A
And
and
324.
320. It was initially registered in 324, but
Do you have
in the
objection?
charge sheet.
No, I don't have any
323.
objection.
Then it is first.
Yes, much obliged.
May I please your lordship?
Yes.
Lordship, a joint application filed by the allies accused and then the
What is the offense?
offense is 186, 189, 225 and 353. Offense is against the public servant.
Where is the FIR?
FIR is at page 23, lordship. Written FIR is at page.
Charge sheet filed or not?
Charge sheet has been filed. Trial has also started, lordship.
Who lost the FIR? SIP,
Victim informant, Lordship. He is the victim as well as the informant.
what is this SIP?
Is a sub-inspector, Lordship.
Sub-Inspector Police,
Probationer, Lordship.
probation.
Lordship.
What is her allegation?
Allegation is that on that very day, Lordship, this alleged accused, they were playing the dice, Lordship.
Playing dice.
Lordship. Section 3 of Prevention of Gambling Act is also attracted. And on their patrolling, Lordship, they went to that spot and who was leading that gambling, police wanted to apprehend him, Lordship. There, since the other alleged accused were the friend of that person who was organizing that dice, they obstructed. That is the allegation, Lordship, from arresting him, Lordship. Being annoyed with the obstruction, Lordship, the SI came back to the police station and lodged the FIR, Lordship.
Mr. Taddo, what is your reply? What is your reply?
This is a joint petition. They have arrived into mutual settlement and compromise.
Do you have objection?
Your Lordship may pass any appropriate vote.
Okay, it will be passed.
Lordship.
All right. What is this meter? CRP. Okay. Yes.
Wait,
My lord, in this case, by order dated 24/6/2024, I was allowed my lord containing in taking up this CRP matter. Also on 24/6/2024, notice was issued in this present CRP. And a direction was given to furnish adequate number of copies, my lord. So my lord, likely copies may be served and thereafter I will take instructions from my department. If necessary, we may file affidavit.
I'll furnish tomorrow.
You have no objection.
I'll file tomorrow.
Tomorrow.
Furnish the copy tomorrow.
The matter may be taken up.
You will provide him the copy.
I will provide.
I'm for the respondent, my lord. I'm say respondent.
That's right.
Mr. Panging, when you will provide?
Tomorrow.
Mr. D. Panging, the learned counsel appearing for a petitioner, submits that tomorrow he will file the reply.
No, I will furnish the copy of the petition.
Furnish the copy of the present application to the learned counsel for the respondents. Yours is Singh.
Yes, my lord, BKC.
BK Singh. The learned counsel, Mr. BK Singh, appearing for a respondent submits that after receiving the copy of the application, he will need some time to take it. I have considered the submissions made by the learned counsels of both sides. Leave the matter again on when do we?
After 4 weeks, ma'am.
At least after 4 weeks.
Obliged.
What is this IA for?
IA, my lord, was for stay, my lord.
For stay.
Yes, my lord. This main petition may be disposed of, my lord. Revision.
The main petition is for what? Today, what stage?
This is civil revision, my lord. Page 39 is the impugn order.
39.
Yes, my lord. Since this is a civil revision petition, my lord,
Hmm.
I'm only on the jurisdiction, my lord.
On the point of jurisdiction.
Yes, my lord.
Deputy Commissioner has jurisdiction.
No, my lord, what happened, my lord?
Hmm.
While returning the plate, my lord,
Hmm.
the deputy commissioner has, my lord, while returning the plate, my lord, he does not have any jurisdiction, my lord,
Hmm.
because he is returning the plate, my lord. Now,
Oh.
while returning the plate, whether he has a jurisdiction
Hmm.
to decide the maintainability of the writ petition, that appeal, my lord. That is the
Oh.
issue, my lord.
Oh.
When he himself says he does not have any jurisdiction and he
My lord,
asks the parties to,
Can it be taken up some other day? I'm not feeling very well.
Okay. Or Mr.
be pitcher out.
B. Pitcher, appearing for the petitioner. Heard Mr. D. Panging appearing for the respondent. Mr. Panging submits that he is not keeping well today. And on that ground, he prayed for an adjournment. There. The case is adjourned accordingly. After 3 weeks,
No, my lord, on 17, my lord.
17.
Yes.
Is it
But
less than 17
Oblige me.
September?
May I please, your lords?
Yes.
In this matter, make appeal,
Hmm.
according to order dated 4/3/2024,
Hmm.
we have paid 50% of the awarded amount, subject to admission of the appeal.
Oh, so appeal is not yet admitted.
My lord, as per order of this honorable court, order dated 4/3/24,
Hmm.
the honorable court has directed to pay the 50% amount, decree amount of the MACT
Hmm.
after within the 4 weeks.
Hmm.
However, the appellant has not so far paid the 50% decree amount of the MST. So accordingly, my lord,
The money was directed to be deposited somewhere.
my lord, MST tribunal at the UPR, MST tribunal. So
Uh,
lordship,
Mr. Decca, what is your reply?
so my lord, the company is deducted 25,000 NFL, which was earlier paid, my lord.
Hmm.
So the company deposited 3,75,000 instead of 50%, 4 lakhs. 4 lakhs is 50%, and company deducted 25,000.
But if
What-
we directed for deposit 50%.
Yes,
You have to deposit the
50%
money.
amount has not been deducted, and thereafter, my lord, this decree holder has filed money execution before the Learned Court of Session, District and Session Court at the UPR.
Very good.
My lord, the company may be allowed to pay the deducting 25,000 amount because
This one appeal. Where is the appeal? This order sheet should be in the IA. There was an IA here, IA 163. The order should be, we remove this order sheet from there. It should be in the IA. Other order sheet also. This is the. It is already disposed of. This is, it will remain here. It will remain here. Because Mr. Dekka, you deposit 50%.
my lord, so 25% the company is ready to pay. Deposit, my lord.
25,000 is statutory deposit.
Yes,
You have to deposit 50% of the awarded amount as directed by this court.
yes, my lord.
Mr. Yu.
My lord,
Heard Mr. Yu.
50% is no so far, they have not deposited before the tribunal.
Heard Mr. Yu Deka appearing for the petitioner. This court heard Mr.
And Raman.
Rama appearing for the respondent. This court directed the appellate insurance company to deposit 50% of the awarded amount in the tribunal. Mr. Deka has prayed for some time. The prayer is allowed. The appellant is directed to deposit 50% of the awarded amount in the tribunal within next 4 weeks. List
Lordship,
after 4 weeks. Yes.
my lord, the tribunal has already passed order that the appellant has violation, that not comply the order of this honorable court. And tribunal has already passed order on that at
All right,
21/5/20.
I'm giving them another 4 weeks time to deposit.
My lord. Much.
Of life.
Nine.
Yes.
May it please your lordship. Now, this is civil revision petition against the order dated, impugning order dated 9/1/2023 passed 2022, whereby my application under order 38 has been rejected by the honorable trial court, my lord. The facts of the case is that, my lord, the
Notice served.
notice has been served and it has not been admitted yet, my lord. Today, the matter may be admitted and may come up for the full-fledged hearing after vacation, my lord.
Okay.
The
Heard
here
Mr. Peter
appears.
Singh appearing for the petitioner. Petitioner is FCI.
Yes, my lord.
Heard Mr. Bigel, Learned Counsel appearing for the petitioner. You are appearing for both the respondents.
Yes.
Heard Mr.
Arpoyu.
You appearing for both the respondents. The revision petition is admitted for hearing. List after the ensuing vacation for hearing.
Obliged, man.
Whose case is that? None appears for the petition on call. Heard Mr. J saying the Learned Public Prosecutor for the state of Arunachal Pradesh. Heard Mr.
For
respondent
number 2.
Appearing for the respondent number 2. Since none appears for the petition on call, the matter stands adjourned today. List after 4 weeks.
May I please?
Yes.
Well, this application under section 482, my lord,
Hmm.
for quashing the, my lord, FIR and the subsequent judgment. Here is the case, my lord, the admitted position, my lord. The case is, my lord, that the petitioner and the, my lord, informant, my lord, they have been in they had been in relation for 7 years continuously. And my lord, after 7 years, then my lord, some quarrel took place between them. Then the informant, my lord, chased the petitioner from the house.
So they were staying together.
Staying together, completely, as in saying, the petitioner is saying, my lord, as husband and wife living together. And my lord has already considered such issue, my lord. My lord, one judgment is there passed by my lord only, my lord. Where the my lord has categorically discussed here the issue of, my lord, breach of promise and the, my lord, false promise. My lord, when a my lord, Apex Court also has said, my lord, when a boy and girl is living together for 4 and 5 years together, can you say later on that I was, because of the false promise, I agreed for the physical relationship? My lord, I just, this is the case, my lord. May I go to
Where is the FIR?
my lord, I will just show the FIR, my lord. My lord, kindly turn to page number 21, my lord. This is no, my lord, page number 17.
17.
My lord, page number 17. Page number 17, my lord.
Yes,
It's a very long affair, my lord. May I read, my lord?
I am not finding this one.
Page number 17, my lord.
One
My lord, there is criminal petition 188. Another is, my lord, maybe looking for this additional affidavit, my lord. Main petition, my lord.
Another one,
Main petition, my lord.
main petition.
My lord.
This is the main petition.
Page 17. One second. 15 to 18.
Oh, this is the FIR.
My lord,
Here in page 20,
my lord, page number 7.
Miss Gugoi, who lost the FIR?
No, my lord, first it starts from page number 15, annexure 1.
No, who is the informant?
Informant is, my lord, say, Miss Goidoke.
Gugoi okay. This is not. Under the FIR. Against her also an FIR has been. lodged.
Yes, my lord, against what happened, my lord?
Hmm.
Subsequently, what she did,
Hmm.
my lord, she came to my house.
Hmm.
I'm already having first wife also.
Hmm.
And she came to my house, threatened my first wife. Basically, my lord, this she would not have filed this FIR only for the property dispute, my lord.
Hmm.
I will show from the record, my lord, because
I have found this FIR.
my lord, I'll just read out the FIR, my lord.
Yes.
Page number 17, my lord.
Hmm.
To so and so and so and so. I will contains. I will read, my lord.
Hmm.
Respected madam, it is to inform that one Sri Govind Arangam serving as inspector so and so of government presently posted and now has committed.
On list on 25 September.
29 is Sunday, my lord.
25 September.
25,
September 25.
no issue. Obliged. Much obliged.
At 2 I will come.
My lord, I may be allowed to withdraw this petition.
And to withdraw it.
Yes, ma'am.
The learned counsel, Mr.
R.L. Tungan, ma'am.
I,
R.L. Tungan.
appearing for the petitioner submits that he has instructions to withdraw this revision petition. I have also heard Mr. D. Ado, Z. Ado.
G. Ado.
Additional public prosecutor for the state of Arunachal Pradesh, heard Mr. Appearing for the informant. The revision petition stands disposed upon adjournment.
Masuk.
Obliged.
Yeah, please, ma'am. Yes.
My lord, I have received one IA yesterday.
Your Honor.
There, they have alleged certain things which need to be
Your Honor,
clarified, lordship.
Your
I need
Honor,
instruction from my client, lordship. I need some time to file reply.
Your Honor, the revision is today fixed for admission. And kindly see the order dated 16/7, passed by this honorable court. No, why the IA is filed? Kindly, my lord. This is a very serious matter, my lord, for which we have to file the IA. Because, my lord, kindly see page number 13. You just tell me why you have filed the IA. My lord, a petition under Section 5 Limitation Act was filed by them for condonation of delay in preferring appeal on 29/8/2023. So that was disposed on 1/3/24 in connected civil appeal number 5. So
Condonation petition is dismissed.
allowed,
Allowed.
and which is impugned in the revision petition
Oh, okay.
because of perversity and arbitrariness. So that is pending.
You filed the condonation petition.
No, they filed the condonation.
They filed the condonation.
It was allowed and we have preferred it in revision. That is pending, in which they are seeking time and again and again. Now, what happened? When this revision petition was going on 18/7, when the appeal was listed, so I apprised the appellate court below that because condonation delay was granted, appeal was not admitted, so formal notice need to be sent to the
party, respondent, and thereafter on 18/7, an order was passed. Kindly see the order dated 18/7. कौन सा page में है? Page 19. They are committing illegalities, irregularities, and they are tampering with the order sheet. Kindly see page 19, madam.
Page 19,
Page 19, madam.
page 19 of what?
I. My lord found it.
Yes.
This is kindly see on the top, civil appeal number 5. So Mr. G. Seke appears for the respondents and has submitted that he represented the respondent in Miss Case number 96 only. As per procedure of the condonation petition is registered first and heard, and if the petition is allowed, then the appeal petition is registered and a formal notice is issued after hearing the appellant. In the present instance, the appeal petition itself was registered along with the Miss Case number 96/2023. Also, there is no instruction for him to, from the respondent to represent him the appeal. Therefore, formal notice may now be issued to enable the respondent to engage any counsel of their choice. B. Micro appears for the appellant and he has no objection if fresh notice is issued. So issue notice in appeal number 5. Now kindly see the next page. Here comes the, now here notice was issued on 23/7/24 in an appeal number 3 of 24.
Not for a condonation petition.
No, condonation petition notice was issued
Yes.
and accordingly we appeared. We filed objection. We raised objection and showing that they have filed false statement on affidavit. So it was not considered and it was allowed. So for which we have filed revision. Now in the connected appeal number 5, the order dated 18/7 is clear that fresh notice was directed to be issued on 18/7/2024 in the appeal number 5. But in the meantime, kindly see page 21. This order dated 22/7. Only 5 days later, what happened that this petition, they filed a fresh appeal after 340 days of delay. And what is, kindly see this order. The present appeal has been preferred under 15 against the same impugned judgment. Arunachal Pradesh Amugam, setting aside the decision dated 17/4/2023 passed by the village authority customary court. The appeal has been filed after application of delay. Condonation delay of 74 days was allowed by this court by order dated 1/3/24. And this was allowed in a petition filed in the year 2023 in preferring an appeal number 5 on 29/8/23. But this order is showing that no, appeal has actually been preferred after more than 1 year. And this is a new appeal, number 3. So now against the same judgment and order,
This is a different appeal.
no, different appeal for the same impugned judgment. And the lower court is saying that since I have condoned the delay of an appeal which was preferred in the year 23, so that will come into effect for this appeal. That means this appeal is filed admittedly on 22/7/24.
So there are 2 appeals,
There are 2 appeals against
same judgment.
same judgment. And they are doing this.
But
And next,
this
my lord.
condonation order may not be applicable in other 2 cases.
No, my lord, because how can there be 2 appeal against the same impugned judgment? And going simultaneously in one record. And there is tampering with order sheet. Because on 18/7/2024 order, it was clearly mentioned list on 16/9/2024 for SR, page number 19. In appeal number 5. Now they've preferred an appeal.
Appellants are different.
Same judgment, same impugned judgment, same parties. So they are manipulating the records, they are hijacking the appellate court below. They are tampering with the order sheet.
That is
Kindly
true,
see,
Lord.
just a minute, allow me. Kindly see the next 22 page. Kindly see the notice. This
Continue.
Notice, whereas the plaintiff above have filed civil appeal against judgment passed by the Gambura in so and so Arunachal Pradesh in connection with Shai Chilaki Amuk so and so. Hence, you are hereby summoned to appear in this court in person by lawyer on C. Kindly see with tampering. This is tampering. Orders has been cancelled. Whitener was applied. Thereafter again cancelled. Then again 22/8. Now date is preponed. From 16/9, date is preponed. And the irony is that this tampering is also noticeable in the order sheet. In the order sheet, my lord. Page 23, my lord. Kindly see page 23. This is a tampering with the order sheet. 23, the same order. They are doing things at their whims and fancies. They have the audacity to manipulate with the records, and they are lingering the revision here by not filing the objection.
Condonation petition was for 05,
For 05.
but
Appeal was preferred in 03/24 after more than 1 year, 434 days. And the appellate court is saying that since I have condoned the delay 1 year back, so it will apply in this case also. And thereafter, this tampering with all this record. So this is a serious matter. First, they file false statement on affidavit. They are required to file objection here to give reply. And instead of filing,
understand, Ginny, what is
Lordship,
your reply?
Lordship, I need at least 1 week, Lordship.
1 week.
Lordship.
Okay, let him come after 1 week.
my lord, my submission is that the appeal may be admitted. They can file objection any time. Appeal may be admitted. Records may be called for because they are tampering again and again with the records. This is height. I'm astonished that how come they can show the audacity to tamper with the order sheet. Kindly see my
Learned Counsel, Mr. G. Soikia, in the I appearing for the applicant. Or Mr. J. Ginny, appearing for the respondent. This application is filed.
my lord.
Praying for stay of further proceedings of civil appeal number 03 of 2024. Pending in the court of the civil judge, senior division, Rowing, Lower Dibang Valley District. Mr. Zini has prayed for 1 week's time to file an objection. I have considered the submissions made by the learned counsels of both sides. List a matter again on 21 October.
My lord.
Till then, the further proceeding of
Lordship,
civil appeal number 03 of 2024, pending in the court of civil judge, senior division, Rowing, Lower Dibang Valley, Suleiman State.
Lordship, may I submit one thing, Lordship? The impugn order.
Okay, you file a
condonation-
written objection. You file written objection.
Lordship, already the interim prayer that was made by the petitioners herein, Lordship, was rejected by
No, in appeal number
coordinate
5,
bench.
appeal number 3. That was in appeal number 5.
Okay, all right, I have passed the order. Is next.
Obliged. My lord, a revision may be admitted, my lord, because LCR is required, man. It is fixed for admission and they are not filing the objection. They are lingering.
In the CRP,
Yes.
heard Mr. G. Soike appearing for the petitioner, heard Mr. C. Ginny appearing for the respondent. The revision petition is admitted for hearing.
LCR may be required.
LCA is not required.
Okay, man.
List on 21 October.
Lordship, October or September, Lordship?
October.
21.
Can it be listed early, Lordship?
I'll take a break now. All right,
Obliged.
Yeah, please.
My lord,
I'm taking a break now.
my lord.
For some time.
Is my lord 468 only, my lord, 4G. Now, interesting, my lord, here in this case, my lord, there is no FIR so far this alleged offense is concerned, my lord. This is something the case, my lord, this FIR pertain to some other organization, my lord. The FIR was filed, my lord. Then charge sheet was filed,
Where is the FIR?
my lord, I will come, my lord.
Where 17, please?
My lord, page 17, my lord. Page 17, my lord. May I read, my lord?
Yes.
FIR against misuse of Taekwondo fake certificate to able under meritorious sport quota regarding. Now, my lord, this FIR pertaining to Taekwondo, my lord. I am, my lord, so far, I am the petitioner number 1, is the office secretary of Arunachal Pradesh Karate Association. This karate is different, then Taekwondo is different. Now, this, my lord, this FIR was filed against Taekwondo, using of Taekwondo fake certificate. I'll just read now. It is to inform your good office that the government of India has notified 63 sports discipline by reference so and so, copy enclosed, in which Taekwondo is also in the aforesaid list to be recruited under meritorious sports person. Subsequently, government has also adopted by resolution so and so and so. Unfortunately, it has been given to understand that some person who are not the players of Taekwondo are using fake medal participant certificate in various departments without any knowledge. Therefore, your authorities request to investigate the matter to consult so and so. Now, my lord, what happened? This FIR is particularly basically Taekwondo Association saying that some of the sports person are using the fake certificate. Now, the police, my lord, carried out the investigation. Charge sheet was filed. Till that time, we are nowhere. Supplementary charge sheet was also filed. We are not there, my lord. Then, my lord, second supplementary charge sheet, I will show, my lord. Now it's coming up saying that in the Karate Association also, few individuals have used the form number 1. My lord, I will just tell what is this form 1 number. Here, my lord knows that 5% is there for the under the quota sports. Those who are meritorious sports person, my lord, while to avail the quota, my lord, they have to submit the form number 1 while applying the job. So in this case, what happened, my lord, because Karate Association also, some of them participated, applied for the job. Then, my lord, at that point of time, there was a corona pandemic was there. Then, my lord, this form number 1, this, my lord, it is to be signed by the General Secretary of all Karate Association of India, who is the petitioner number 2 here in my lord. So he is to sign the signature form number 1. So what he did is, my lord, because in the corona time, those intended candidates, they cannot go to the Delhi, my lord, to get the signature. So what he did is he authorized the petitioner number 3, who is the general president or who was the president of the Arunachal Karate Association, saying that you use my facsimile signature and issue the form number 1. My lord, this all the 3 they are together here in the this petition, criminal petition. Now I am so far, my lord, petitioner number 1. I am the office secretary. Now, my lord will see. Petitioner number 2 has authorized petitioner number 3, my lord, that you use my facsimile signature and issue the form number 1. Then, my lord, I am being an office secretary. If my president asks me, my lord, that you use this facsimile signature and you issue the form number 1, my lord, can I, my lord, deny that part, my lord? I cannot deny that part, my lord. This clarification has been done, my lord. Kindly turn to page number, my lord, authorization letter, my lord. Page number 86, my lord. My lord, kindly turn to page number 86, my lord.
86.
86, my lord. May I read, my lord?
Just a minute.
Authorization letter. Some individuals from Arunachal Pradesh contacted me and introduced themselves as sports person of karate. They informed me that they needed Form 1 to be issued by the Karate Association of India to apply for government employment under the meritorious sports person quota. However, they were unable to come to the association office due to the COVID-19 pandemic. Considering their genuine grievances and after ensuring that their participation was recorded in the records maintained by the Karate Association of India, I hereby authorize the President and the General Secretary of Arunachal Karate Do Association to issue the form number 1 and sign with my facsimile digital signature. However, President, General Secretary are directed to verify and scrutinize the genuineness of the sports certificates submitted by the candidates and records of their participation maintained by the Arunachal Karate against which the form number 1 is to be issued. Thereupon, form number 1 with my facsimile digital be issued against the following sports personnel. These are the person, my lord, 8 person under the Karate Association against whom this form number 1 was issued, my lord. Now, my lord has seen
Normally, who issues the form number?
this, my lord, Ambedkar Gupta is the petition number 2, my lord, the authority who has given the issue, my lord. This is, my lord, page number 87.
No, he issues the form number 1.
My lord, page number 87, my lord. He has authorized, my lord.
Okay.
Ambedkar Gupta. He is the petition number 1 here, my lord.
He can authorize for all the associations.
Not all the associations, only for karate.
Oh, only for.
I am here only for karate. I am no for other. I am the office secretary, my lord. Petition number 1.
No, who issues the form number 1 for Taekwondo?
Taekwondo, this, my lord, this Ambedkar Gupta, petitioner number 2.
For Taekwondo,
General
they have a
Secretary.
different association.
Huh?
General Secretary.
Yes, I understand.
My lord, Ambedkar Gupta, General Secretary, Karate Association of India. For Taekwondo, my lord, another body is there.
Oh, okay.
Nothing to do with us, my lord. So I am, my lord, only, my lord, kindly see my status. I am the humble man. I am working as an office secretary in the Arunachal Karate Association office. My lord, when the petition number 2, who is the General Secretary of Karate Association of India, and the petition number 3, who is the president of the Arunachal Pradesh Karate Association, if they ask me to issue the my lord form number 1 using the facsimile, well, how can I be said, well, this is a forgery? Only forgery charge has been made. Now, if both the person has come to the court saying that we have authorized to use my lord, then my lord, no case is made out. This apart, my lord, where is the FIR in this case? How, my lord, the FIR pertains to my lord Taekwondo. How the police investigation can by filing charge sheet, my lord, supplementary charges, how the case can be made out, my lord. Even on that account also, my lord, this case is legally not permissible, my lord. So, my lord knows, my lord, this Narendra Singh, my lord, that when there is abuse of process, my lord, there is a remote chance of any possibility of conviction, my lord. And here is the case, my lord, when the person, the authorized person is saying, I have asked him, I am the authority that no, there is no wrong. And all this form number 1 is genuine. These people, they have participated, my lord. Then, my lord, where is the question, my lord? This will only be abuse of the process and from only the office secretary, my lord. Petition number.
All right, yes. Say.
So far, the present accused is concerned, my lord. It appears that he's the office secretary. And on the basis of the authorization given by the Karate Association of India to the Arunachal Karate Association, he has used the facsimile signature. And to that effect, they have produced the authority as well as the deed of agreement as well. So therefore, my lord, I don't think there's any offense which attracts you.
And my lord, item number 26, my lord, these are those individuals, 8 numbers, my lord, to whom this certificate was issued, my lord, because they are the person, my lord, they have not forged anything because it was issued by the office, my lord. Item number 26, my lord.
26. 26.
It is something like that, my lord. These were the, my lord, person to whom the form number was issued. They have no connection, my lord, to get the form number 1. Now, my lord, this form number 1 has been issued.
FIR is the same.
FIR same, my lord. My lord, same charge sheet, my lord. Same supplementary charge sheet.
Oh, it's okay.
They are not, my lord. They are the only, my lord.
These petitioners are from the Karate Association.
Yes, my lord. My lord, this form number 1 were issued to these 8 people. So they have not procured because they have applied for it and it was issued by the association. It is only, my lord.
Same case, same charge.
Same charge, my lord.
Like first.
Thank you.
Well, madam, interim, pursuant to this interim, I appeared and recorded my statement on 1st.
Okay.
And case there was called for,
He has appeared or not?
Yes, yes, ready, receipt.
His statement is there.
Yes, receipt.
It's a commercial, dispute given to a criminal color.
Okay.
Made a promise that I'll get some scheme, and both of them are from BJP.
Heard Mr. T.T. Tara. Regarding counsel appearing for the petitioner. Heard Mr. G. Tade. The learned additional public prosecutor for the state of Arunachal Pradesh. Para. This is an application under section 482 of BNSS 2023. Praying for pre-arrest bail irrespective of Naharlagun PS case number 68 of 2024. Para. This court earlier allowed interim bail to the petitioner, and pursuant to the interim order, he has appeared before the investigating officer and has cooperated with police investigation. Para. For the aforesaid reasons, the petitioner does not deserve to be detained in custody. His pre-arrest bail application is allowed. The interim bail order granted on 08/08/2024, passed by this court, stands made absolute.
CD may be returned.
CD may be returned. Sixteen. 16 is for orders. Notice served or not?
May I please, Your Lordship? Here, respondent number, he expired, and accordingly, a new respondent has been implemented, his son. And accordingly, the cause title was also amended. And accordingly, a step was taken, but it has not been reflected on record. A step was taken actually to the respondent number 1.
Respondent number 1.
Yes.
Notice
Now
returned.
newly implemented party, that is.
Notice returned or not? Have you taken steps? You have already taken steps. You have already taken steps
Yes,
for service of notice upon the
yes,
respondent number 1.
yes. But it is nowhere whispered in on the record.
Heard, Mr.
D. Williams.
Appearing for the appellant. Await for the service report in respect of respondent number 1. Is there any interim order pending?
Yes, there is interim order.
At least after 4 weeks?
That may be
The
continued.
interim order passed earlier will continue until then.
Obliged.
My lordship,
Yes.
lordship, service report in respect of respondent 1 and 2 is still awaited.
Not yet returned.
Yes.
What you will do?
Lordship, I have taken the steps on 30.
Okay, all right. You
Yes,
want to take first steps or wait? You want to wait?
Yes, sir.
Heard, Mr.
L1,
Appearing for the appellant. Service of notice in respect of, await for the service of notice. In respect of respondent number 1 and 2.
1 and 2.
1 and 2. This after 4 weeks.
Hold on.
Mayor, this item number 18, my lord. I am going to file one amendment application also. This matter may be listed after a week, my lord. This item number 18. I would like to file one amendment application. There is some mistake in my civil division petition.
Okay.
So this matter may be listed after a week.
Okay, all right. The learned counsel, Mr.
B. Picha.
Appearing for the petitioner submits that there are some mistakes in the petition.
Yes, my lord.
Therefore, he wants to file an interlocutory application
Yes, my lord.
praying for correcting those errors. I have also heard Mr.
N. Novang, my lord.
Appearing for the respondent. The prayer of the learned counsel for the petitioner is allowed, least after 4 weeks.
My lord, after 1 week, my lord. I will file.
After 2 weeks.
My lord, obliged.
None appears for the appellant on call. RMST Genie, the learned counsel, additional public prosecutor for the state of Arunachal Pradesh. Least after 3 weeks.
Your lordship, I'm for the petitioner. And I have already taken steps upon the respondent through court registry post.
Notice not yet returned.
Yes, your lordship.
Notice or return.
May I please, madam? Madam, I was representing respondent number 2 here. And now after amendment, I have been instructed, I'm filing the Wakalan of other respondents. 2 to 8, I'll be representing 3 to 8, the victims, all the victims.
There are only one respondent here, private respondent.
Your lordship, after amendment, there was an IA praying for implement of other.
These are to be corrected first.
Actually, they have filed the amended cost title as per the direction of this honorable court. On the previous.
On the previous occasion, yes, I have already filed the. On the previous occasion, I have filed the amendment cost title. Lordship will.
The learned counsel for the petitioner submits that she has already filed an amended cost title.
Maybe.
Oh, sir, it is here. Now you will represent all the these private respondents.
Yes, madam. The informant and other victims.
Hard MS, what is your name?
Emiaram.
Appearing for the petitioner, Hard MS.
And your lordship, I humbly pray this matter may be listed on this 16th of September.
There is another matter.
Now, this instant matter may be fixed on 16th of
You
September.
want it on 16.
Yes, for hearing.
Just simply write list on 16 September for orders.
Your lordship, also the amended copy has not been served to us. That may be served to us, your lordship.
Amended copy of the
The petition after the implement of the parties. Yes, I've got the extra copy. I'll serve it. right.
extra copy of the amended title page of the petition shall be provided to MST Genie. Mr. Bhattacharya is sitting here. 24.
Yes, come up for suspension of sentence.
What is the punishment?
10 years with 1 lakh fine. Paper book is already ready.
When will you hear the argument?
Because my argument on suspension of sentence and on the final hearing will almost be the same.
Then we will hear the appeal. It will be better, the appeal will be disposed of ultimately. When?
Lordship can, lordship can find it till 12. It is convenient for the government.
Bail is not possible.
Then after 3 weeks, 4 weeks.
24?
24, lordship. Lordship, can it be somewhere about last week of October?
First week October, first week. Yes. Third October?
Yes, sir.
It was 310.
Week October,
Fifth is a Saturday.
8 October. Tuesday.
No, 8th October is a holiday.
And then 9 October,
The Puja vacation.
after Puja, like
22?
22. Then lordship may kind of make it in 23rd.
20?
23rd, 2, 3.
23rd. Heard the learned counsel, Mr. A. Bhattacharya. In the IA first, appearing for the applicant. Heard MST Genie, the learned additional public prosecutor. 22. Okay. H. Lakshmi for the learned additional public prosecutor. These applications shall be considered at the time of hearing of the connected appeal. And in the appeal, lawyer's name same, you were also appealing. Oh, it's a- lawyer's name same, list on 23rd October for hearing.
Your Lordship, item number,
Item number 22. I am for the applicant.
Yes,
I am for the applicant.
criminal petition.
Criminal, criminal appeal, my.
after the 20.
22 is a criminal petition.
20. Yours is 20. Yours is 20. Ah.
Oh, sorry then.
I will take it up on some other day. List this matter on 16 September.
Lordship, interim is there, Lordship. Interim
The
order.
interim order pastilless will continue until when?
And your letter.
Non-appears for the appellant on call. List again on 24 September. For hearing. May I please, Your Lordship? I will take it up on some other day. You can suggest it. Suggested it. 26 September. 26 September, Lordship. After vacation. Then after vacation, 23rd October.
Well, can it be on 22nd?
Well, 22nd October.
22nd.
Leave this matter on 22nd October for hearing.
All right.
22nd.
22nd October. I will take it up on some other day. This is last time. Do you want it in the month of September or October?
For tomorrow, Your
Tomorrow,
Lordship.
September or October?
October month.
October. Release this matter on 22nd October,
23rd, my lord.
23rd October.
My lord. 23rd. Hmm.
October.